Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning, everyone. I'm Tiffany Thomas, and today I am co-presenting this webinar with my colleague, Calvin Toe. We are both employment law lawyers here on the SpringLaw team. We want to thank you all very much for joining us. We're here to present on a very exciting topic. We're going to be looking at some Employment Standards Act updates and upcoming workplace legal changes that you may need to know about. So for those new to our webinars, welcome. We are a virtual Canadian law firm that specializes in employment and contracts law. We do have a questions box open in the chat. You can feel free to ask us questions throughout the presentation. We're going to save some time, which I'll talk about in a moment, to get to those questions at the end of the presentation, but feel free to pop them in as they come up, and we will do our best to get to them. If we can't get to your questions or comments during today's presentation, please do feel free to follow up with us afterwards. The slides are actually available for your download through the Handouts tab. And if you're looking for some more resources, we would really encourage you to visit our website at springlaw.ca, which is just really a treasure trove of a whole number of really helpful resources, including our award-winning blog, a link to subscribe to our monthly newsletter, and info on our subscription program for employers and some do-it-yourself legal products. So please do check us out there. So we're going to start off just very briefly with letting you know who you're receiving this presentation from today. So my colleague Calvin is a former journalist and news anchor with a very strong interest in technology, really bringing a unique perspective to workplace innovation and communication. Calvin has a great deal of interest in tech and entrepreneurship, with experience in drafting contracts for startups and founders. And I recently learned this about Calvin, and it blew my mind. Yes, he's built his own computer. I can say, Calvin, bravo. I would have no idea where to start. Here at SpringLaw, he supports both employers and employees in their workplace problems. Of course, as I already mentioned, I'm Tiffany Thomas. I'm another lawyer here at SpringLaw. My practice predominantly focuses on advising employees, although I'm still more than happy to work with our employer side clients. I'm also SpringLaw's legal skills development portfolio lead, so I have the absolute pleasure of assisting our lawyers in the ongoing development of their legal skills. And I don't build computers in my spare time. Basically, all of my spare time really revolves around taking my dog to visit my family and friends. That's basically what I'm doing day to day. We're going to start off with today's presentation at, of course, pausing briefly to acknowledge the land that we are on. So we would like to say that we do acknowledge that the land on which we operate in is the traditional territory of the Anishinaabe, the Haudenosaunee, and the Huron-Wendat people, as well as the Mississauga of the Credit First Nation. They have stewarded these lands for generations. We recognize that Indigenous peoples lived and thrived here long before the arrival of settlers, and we acknowledge the lasting impacts of colonialism. As part of our commitment to truth and reconciliation, we strive to learn, unlearn, and understand the history and effects of these wrongs. We are very grateful to live and work on this land. Of course, we wouldn't be lawyers if we didn't have a disclaimer. So we're going to briefly pause before we jump into the content of today's presentation, just to provide you with a few legal disclaimers. I will not read this slide. It is here for your clarification and for you to return to should you need to. But I will say that please understand that the content of this webinar should not be relied upon as legal advice. Attending, accessing, or viewing our webinars does not create a lawyer-client relationship with anyone at SpringLaw. We encourage you to apply your own judgment in making use of any of the content from our webinars, including the information in the webinars, because every case and set of facts is different and unique. And so these videos are really for information only. Finally, as sort of is the focus of our presentation today, the law changes very quickly in Canada. So we cannot guarantee that the content of our recorded webinar videos are accurate or up to date when you're viewing them at some time in the future. So again, please do return to this slide if you have any questions. Okay, so with that, let's jump in, and I'm going to start off just by kind of giving you an idea of what this presentation is going to look at today. So as you know, based on the title, we're here to talk about some of the ESA changes. And we're going to really kick off the presentation with Calvin, who's going to take us through why staying up to date matters. Okay, there were quite a few new changes to Ontario's employment law landscape, particularly thanks to the series of Ontario's Working for Workers Act, which were rolled out throughout 2024. Today, the point and purpose of this presentation, we're going to be covering some of the key workplace changes to be aware of. We, of course, in an hour can't cover all changes to the workplace and the legal landscape across the country. And, you know, our focus is going to be here in Ontario. But we are going to go through many of the key workplace changes that employers and employees should be aware of. Okay, it's really critical from our perspective that in an ever-evolving landscape that employers are staying up to date with these new changes. So basically, for the next 50 minutes, we're going to be walking you through the key changes as well as providing you with the practical takeaway on how these changes really impact your workplace. And we've organized this presentation by basically taking away some of the main themes that we saw in these changes. And so today we're going to cover 4 of those main themes that include new protections for workers, new entitlements for job seekers and new employees, an entirely new framework for our growing gig economy, as well as some new health and safety changes that we saw rolled out. So again, we're going to go through these changes. We're going to cap off each of these sort of changes, these themes, with a discussion of the practical takeaway that you need to know about how this impacts your workplace, how you need to go about implementing these changes. And then before we conclude today's session, we're going to talk about, not only some key takeaways of the actual changes, but we're also going to talk about some changes that are upcoming that we want to kind of put on your radar for the next year or so. And we also want to just briefly touch on some of the trends we think that employers need to keep their eyes peeled for on a go forward basis. And then, of course, we're going to, as I mentioned, save some time at the end of the presentation for a Q&A session. So with that, I'm going to turn it over to Calvin, who is actually going to take us through why staying up to date matters. Over to you, Calvin.
All right, thanks very much, Tiffany. As you mentioned, the workplace is changing. And one of these changes is that gig work is on the rise. A recent survey showed that nearly 1/4 of Canadians, 22%, or about 7.3 million adults, are taking part in gig work of various kinds across the country. So if you do gig work as part of a digital platform like Uber, Uber Eats, Instacart, TaskRabbit, there are new protections for you that we're going to cover. An increasing number of people are doing that as a side gig. Now, another big change is the increasing use of AI in the workplace by employers, by job seekers, by employees. It's all going up. There are some changes that we're going to talk about in regards to the use of AI in job applications. And this change impacts employers when you're recruiting for positions. You're using AI to help in that process. Now, the job market is becoming increasingly competitive for employers. A recent survey showed that 79% of permanently employed Canadian professionals said that they'd actually leave their jobs to become independent contractors. Why is this? They said better rates of pay, greater opportunities to develop skills, and more flexibility as some of the reasons behind this. This is all leading to difficulty in retaining talent. According to a recent survey, 77% of employers still face significant challenges in finding skilled talent. All of this means that employers are facing higher expectations, including complying with constantly evolving laws, which we're talking to you about today.
Thanks, Calvin. Those are some really interesting statistics. Obviously, this huge number of gig workers are increasing. And so, hopefully there are some gig employers out there listening in today to better understand how this new framework is going to impact their employees' rights. And of course, something we hear frequently from our employers is just this notion of trying to attract and then retain talent, right? So again, just to sort of echo what Calvin's saying, this just great deal of importance on really keeping up with changes to ensure that you remain competitive and capable of retaining that talent, and of course, remaining compliant with laws. So with that, let's sort of jump in, and we're going to start with talking about some of these key changes. And in particular, we're going to start with talking about this first sort of theme that we saw amongst these new changes, which was expanding protection for workers. So as most employment lawyers will tell you in Ontario, we do live in a very employee-friendly jurisdiction. And that really just carried on through 2024, 2025, and what we expect into 2026. But we saw a couple of really key, interesting changes that we wanted to specifically touch on. So the first was that there was a change to the actual definition of how harassment is defined under the law. And so specifically what we saw here was a change to include harassment that occurs virtually. And that's through the use of information and communication technologies. So we're talking about things like email or chat, okay? Now, we do want to recognize that this new change is actually already in force. So this might come to a bit of a surprise to some of the folks listening in today, but it's important to recognize that this definition has already been changed. And so it's important to kind of consider, which we're going to get into in a minute, how this can impact your workplace. So again, sort of before this change, there wasn't this recognition that harassment in the definition might occur virtually through the use of information and communication technologies, okay? So what we sort of suspect from our perspective is that most of you listening in today are probably thinking, yes, well, I assume that maybe harassment could be extended in this way, or that this was actually happening in our workplace. But here, what we have is an actual codification, a recognition by our lawmakers to say, hey, employers, you need to be aware that legally harassment can now include instances that occur virtually through things like email and chat. Okay, so this is an incredibly interesting change, certainly from employment lawyers' perspective, but also one that's certainly going to impact the way that you have to be considerate of harassment in the workplace. So Calvin's sort of going to speak in the next slide about how all of these changes impact your workplace, but we did want to pause momentarily. This is a particularly important change, certainly one that's likely going to impact many of the workplaces and many of the employers who are listening in today. And we really want to, highlight here that this change is really just a great reason to audit your harassment policies, procedures, and the sorts of training that you provide to your management team and the employees who supervise your workers. Okay, so from my perspective, this is just a really great excuse to take a quick look at those policies, procedures, and training and ask yourself, number one, do my existing policies, procedures, and training, are they compliant with this new change? Can I recognize that harassment is occurring virtually? But I also think it's just such a great opportunity to really make sure that otherwise these policies, procedures, and training are up to date with the law more generally. And the reason why I raise this is because as a lawyer who frequently consults with employees regarding harassment, one key question that I have as their lawyer, pretty early on to those sorts of conversations is, what does the workplace policy say about harassment? And unfortunately, I am frequently and really too often hearing either they don't have a policy in the workplace, the employee doesn't know where to find the policy, or if we do locate one and we take a peek at it, typically, there's some things in there that are not fully compliant with Ontario law, right? So to avoid that kind of liability and risk in your workplace, I just think knowing that there's been this change that now recognizes that harassment can occur virtually, this is just a great opportunity to take those policies, procedures, training that you provide, audit them, and make sure you're compliant with the harassment expectations in Ontario. Okay, and then of course, more specifically, you now also have to be prepared to prevent and address instances of harassment that occurs virtually through things like emails, chats, and text messages. Okay, so a couple of really key important things that you need to be aware of and be prepared to prevent and address should they occur there. The other change that we saw that sort of fits within this theme of the expanding protection for workers is that the definition of employee has been changed, and it actually now includes individuals performing work during a trial period if the skills assessed are used by the employer's employees or could be used if there are no other employees. So basically, what we're getting at here is that more likely than not, it again will depend on the fact scenario, but trial periods could very well likely now be counted as work time because the worker would be considered an employee. As I mentioned, this change is enforced. So again, it's something you want to be cognizant of as you're sort of offering up a trial period to an employee.
So as Tiffany mentioned, yeah, thank you. As Tiffany mentioned, these changes impact the way you do business as an employer. And next, we want to talk about some big changes to job protected leaves under the Employment Standards Act. So first, there's a recent change to sick leave, and this is the 3 unpaid sick days that all employees are entitled to once they've worked for an employer for 2 consecutive weeks. Now, employers now cannot ask for a certificate from a qualified health professional when employees are using this sick leave. Of course, they can still request evidence reasonable in the circumstances. This change is put in place as of last October, and it was in response to concerns that employees asking for sick notes for these 3 sick days is adding an unnecessary burden to our healthcare system. It's an effort to streamline things. Now, there are also 2 new leaves that we want to cover. One is the long-term illness leave. This was included in Ontario's Working for Workers 6 Act, and it came into effect this past June. It's an unpaid leave, 27 weeks in length in each 52-week period. But the important thing here is that it doesn't have to be consecutive. It can be broken up. Now, to qualify for this leave, employees must have at least 13 weeks of service. They must have a serious medical condition, and they must have a certificate from a qualified health practitioner that sets out the length of time that the employee is going to need off. Now, previous to this, employees only had access to 3 unpaid sick days, as well as time off to care for sick family members, but nothing more for themselves. As an employer, you already have an existing duty under the Human Rights Code to accommodate employees who are sick, even if this means providing them with an unpaid sick leave. This change essentially codifies that expectation under the Employment Standards Act. So, as Tiffany mentioned, it's important to review your policies to make sure they comply. The next leave is the placement of a child leave. And this gives employees up to 16 weeks of unpaid leave. As you know, there's already parental leave under the ESA, but this leave is for employees who become parents by way of adoption or surrogacy. They must have at least 13 weeks of service to qualify for this leave. And employees have to give employers at least 2 weeks prior written notice indicating the start and end date of the leave. Now, on the next slide, we'll see that this next set of changes will affect how employers will recruit for positions. Starting next January, job postings now have to identify several things: whether the posting is for an actual vacancy, the compensation for the position with a maximum range of $50,000, and we mentioned this earlier, whether AI is being used in the hiring process. The job posting now cannot require Canadian experience, and job seekers have to be informed of the outcome of an interview within 45 days of that interview taking place. These changes, of course, add more work for you as an employer. They also address some big gripes that a lot of job seekers have had for quite some time now. Maybe you've experienced this. We've all heard, for example, that it's common to be ghosted during the application process. You apply for a job, maybe you never hear back. Maybe you have an interview and you never hear back. Job seekers are often frustrated that they're applying to jobs with no idea what the salaries are. And so these changes add more transparency and communication to the process. And that ultimately, hopefully, makes recruitment, which is a stressful time for everyone, a much better process for both employees and employers. Now, it's important to note that these changes only apply to external job postings, so they don't apply to internal postings for current employees only. They don't apply to general help wanted signs, and they don't apply as well to recruitment for work performed outside of Ontario. The final thing they don't apply to is employers with fewer than 25 employees.
Thanks, Calvin. Those are some really fascinating changes. I found this theme particularly interesting as a lawyer because before this, we didn't have a great deal of recognition that employers have this sort of duty to extend a certain level of protection or expectation to people that aren't employed by them yet, right? We're talking about job seekers. And so I found this interesting. I'd certainly agree. I think this was likely in recognition of, many of the big gripes that we heard from employees over the last couple of years, not applying for jobs and not really knowing if it was going to be a fit based on the salary. Because of course, an employee is going to sort of potentially look at, an interview with a salary that's much lower than what they need as, maybe not a good use of their time or your time. So I think there's some recognition of those sorts of concerns, but also this concern around, I've applied for, 100 jobs, and of those 100 jobs, I had 10 interviews and I never found out what the outcome was. I think it sort of recognizes that the job market can be a tough place for job seeking employees to sometimes exist, and just providing some level of protection. But again, so fascinating that we kind of had this new element of protection for job seekers. I also just want to mention this other sort of fascinating trend I heard about last year, which is white fonting, which is this process by which employees or job seekers actually will sort of copy and paste the job posting from the onto their resume, but actually go ahead and put them all in white font. And so what they're trying to do there is get past AI tools that might be sorting their application out when they feel like they're a great fit for the job. And, I have certainly spoken to some employees throughout my practice, some friends as well, who express this frustration of, I'm a really good candidate as far as I can tell. But, is there something in this job posting process where I'm basically being selected out and not actually being hired because I'm missing a word or a term that the AI sees as or has been trained as sort of critical for onboarding me? And so what they're basically doing with this white fonting is hoping that, by capturing the whole job posting, but putting it in white font, that their resume will, get past this AI. And then of course the white font is, not visible to someone reviewing the resume on paper. Might be visible if you click around enough on an electronic copy. And so I think what employers have to sort of be prepared to respond to is, you're now having to say whether you're using AI in your job posting process. That, you're going to have to do. So how do you respond to sort of these tricks and tips and things that are going on with employees who are actually applying for the role? Because I think certainly the job seekers recognize that, sometimes AI can be a sort of, obstacle to them getting the job. So I'm going to move on and talk about another sort of interesting new entitlement. Now, this is actually for new employees. So this is once you've done the hiring, and now you have this new employee. So this change came into force a few months ago on July 1st, 2025, and this specifically applies to employers with 25 or more employees. And so now there's an expectation for employers to provide information about the employer-employment relationship on hiring. So basically before the employee's first day of work or as soon after as possible. And there's basically a list of information that you need to provide to your employee. So this information that you have to provide includes the legal name of the employer, as well as any operating or business name of the employer if it's different from the legal name. You also have to provide the contact information for the employer, which includes your address, telephone number, and one or more contact names. The information must include a general description of where it is anticipated that the employee will initially perform work. It also has to include the employee's starting hourly or other wage rate or commission as applicable, the pay period and pay day established by the employer, and finally, a general description of the employee's initial anticipated hours of work. So there's a pretty significant list there, as I'm sure you picked up on, in terms of what you actually need to now provide if you're an employer with 25 more employees to a new employee, either before their first day or as soon after as possible. Okay, and then the question I'm sure on most of your minds is, how am I providing this information? Excuse me. Am I potentially providing it through an email? Sorry about that. My voice has decided to give out. So let me just mute for a minute here and see if I can.
You can just jump in here.
Everyone.
Oh, you're good. Okay.
Yeah, sorry, I'm tired, I guess, or my voice is tired. And of course, it's giving out at the least convenient time here. So basically, I think what we're trying to get at here is, how am I going to provide all this information? And it's a great question, right? And so for me, the sort of most convenient way that pops up, and another sort of great opportunity to kind of audit an important document in your workplace is your contract, right? And so I think for most of you, if you have a contract in place, a lot of this information is going to be covered in your contract. Okay, so first of all, I'd like to recognize if it's your first webinar, you may not know this, but the lawyers here at SpringLaw, we're big fans of employment contracts. Okay, there's a whole host of reasons why it's probably a good idea to have an enforceable employment contract operating in your workplace. So we have plenty of past webinars on that you can check out. But let's assume for a second you do have those kind of contracts in place. Well, I think it's likely that most of these issues are going to be addressed in the contract. Okay, but again, here's a great opportunity to pull that contract out and make sure you're complying with this new law and say to yourself, okay, here's my checklist. Am I addressing everything that's in the contract? Okay, so you want to be meeting these expectations in terms of the information you now have to provide. And again, it might be in the contract, check it. If not, you have to come up with another way to make sure that you're providing your new employees with this list of information. Okay. And then just to sort of finally touch on, all of these new changes that Calvin mentioned in the previous slide, obviously you're going to need to, as a sort of practical takeaway here, do a bit of an audit on your job posting and hiring process, okay? So you need to get prepared to be able to acknowledge the compensation range in the posting, as well as, introducing a mechanism to ensure basically that you're not ghosting your candidates, okay? And that might be new for you. So you want to make sure that you're sort of falling in line with these new expectations around what you can and cannot address in the job posting, along with what you must address, use of AI, those sort of things, as Calvin talked about. And then you want to make sure that you have this sort of mechanism for how you're actually going to update your candidates on the outcome of the role. I'm going to turn it over to Calvin now to talk about this new framework for digital workers.
Sounds good, thanks. So this is what we mentioned earlier. This is Ontario's new Digital Platform Workers' Rights Act, or DPWRA. And basically, it introduces a new framework for workers who perform digital platform work, such as ride sharing, delivery, courier services, or other designated services, where the payment is based on a person doing individual assignments facilitated by a digital platform. So in practical terms, that means gig work, where you use an app to get assignments and get paid. So generally, this law sets standards on what constitutes a digital platform. There are also standards on when work assignments begin and end, standards for information that has to be provided to the digital platform workers. For example, the kind of information that they have to be provided is how their pay is calculated, how and when tips are calculated, and it also requires that workers be notified of their removal from the digital platform. So there have been instances where people have been banned from apps. This provides them with knowledge that they have been banned and notification, so that they're not left in the dark wondering what happened to their account. This also includes other terms that we're used to seeing in employment standards legislation, like a prohibition on reprisals for exercising their rights under the Act and penalties for contravention of the Act. Now, a big reason why this has been brought in is because historically, and it's ongoing, that digital platform workers like Uber drivers, food delivery couriers, there is a great power imbalance between them and the platform that is providing them with the work. For many people, this is their only source of livelihood. And for some people, it's a big source of their livelihood. With the economy the way it is, people are turning to gig work as a means to get by and to make enough money, because their primary job in many cases does not provide them enough money, just a symptom of the economy. And so because of that power imbalance, there have been concerns that gig workers don't have enough protections. So I'm going to take a moment now to address a question that came in through our chat. One of our clients says they use contractors through gig type apps for delivery work. They're wondering if the new digital platform rules apply to them, and what information do they need to start providing their workers. So the short answer is it depends. We have to take a look at this arrangement, what the gig type apps are. I encourage you to get in contact with us so we can provide you with some specific legal advice once we take a look at everything that you're using in your situation. If they do apply to you, a very good way to provide workers with this information is in the contract that they sign at the beginning of their relationship with you. That way they have detailed information on their assignments, how they get their assignments, detailed information on what kind of behavior would get them banned from their app, some other information on how the compensation for each delivery, for each assignment is calculated, and how their tips are calculated. This is all great information that you can put into an independent contractor contract, and we have worked on those. So I encourage you to get in contact with us. We can review your contract if you have one, or we can come up with one for you. Now, on the next slide, we'll talk about some recent and upcoming changes to Ontario's Occupational Health and Safety Act. So the first is in regards to personal protective equipment, or PPE, such as face masks, for example. Now, as an employer, you now need to provide PPE that is properly fitted and suitable for diverse body types, including women, and for specific work conditions. So they need to fit your workers. There's also increasing authority of the Chief Prevention Officer with this change. And these two changes came into effect last December, so they're already in effect. There is also a recently new change, and that is the requirement for employers to maintain clean and sanitary washrooms. This came into effect last July. I'm sure many employers are already doing this. So this likely does not add a new responsibility for employers, but just codifies something that many of you are already doing. I'm sure you want to provide clean and sanitary bathrooms. Now, starting next January, there's going to be one change. Employers have to then begin maintaining records of cleaning, and there are some specific record keeping requirements that they need to meet here. So in particular, you have to post the record in a conspicuous place in or near the washroom, or you have to make it available electronically for your workers to see, as long as your workers know how to access it. You also have to include the date and time of the most two recent cleanings of the washroom facility. Now, you often see this in a retail setting. For example, if you're shopping in Costco, for example, one of my favorite stores, you see a log of how often the washroom's been cleaned. So this is not necessarily an onerous obligation. One of our clients is asking, one of our participants rather, are asking, what are the new requirements? So we've covered that. And they also want to know what the best way for a small business is to keep records and stay compliant without drowning in paperwork. And that's right. These things have to be done practically because you're a small business owner. You're very busy. You don't have time to do all these things that may not be the core of your business. Of course, you have to do them. And so a great way to do this, this one doesn't seem too onerous. You just have to post a piece of paper whenever you're inspecting the washroom, just put the time and the date in a little chart. Or another way to do it is to have the record available on a company intranet. If you have a platform available to your employees already that they can access. And this can all be built into your policies in terms of where employees can access certain things. So these are things that we can all review for you as well. I'll hand it back to Tiffany.
Thanks, Calvin. That's some great information. Obviously, some really practical takeaways there. I think it's so important, as you said, to recognize that these are, again, additional obligations for employers. We know you have a lot on your plate already. So, not only are we here to talk to you about the law, we're also always here to talk to you about strategy, right? We love to strategize here at SpringLaw. So if you had some questions around how can we do this in the most practical way, the great thing about our job is we talk to employers day in, day out. We are creative folks by nature, so always happy to chat with you about how to actually implement this all in a way that's, reasonable for you. Okay, so as we mentioned, we want to briefly talk about some changes and trends to watch for. Okay, and so this is really two sort of similar topics, but we know two things. We know that there are some upcoming changes, which we certainly want to talk about. Now, these are all dependent on whether they pass through the legislature. So this is really, a heads up of what could be coming. But what we also want to sort of cap off this particular discussion is talking about, well, what could be coming, right? Just a little bit of speculation on our part as folks who tend to watch for trends sort of across employment laws from really, the entire country. So let's start by just talking about the Working for Workers 7 Act, which is actually currently before the legislature. So if passed, the Working for Workers Act 7 is going to introduce even further changes for job postings, which interestingly focuses on ensuring that fraudulent job postings can be reported and that the employer has procedures in place to handle such reports. So again, I really want to hammer home these changes, not law yet, they have to be passed. But I think, we really wanted to recognize the importance of there's more changes coming. I suspect if this is passed, of course, good degree of likelihood it will be passed given the current makeup of our government. And again, here we see this sort of fitting in with this theme, this growing sort of trend towards protecting job seekers, right? And this sort of push towards a recognition that there are potentially fraudulent job postings out there, and ensuring that the employer has, a procedure for handling the report of such fraudulent postings. Okay, so again, I think this sort of fits in with this theme that we saw, this questioning by a lot of job seekers of, what's going on in the job market? Are these postings really real? What are the details on them? What are the expectations? How is my application being assessed? So again, I think this potential new change is driven by this recognition of there are a lot of questions amongst job seekers about the current, job market and its conditions. And then this is a sort of recognition that perhaps there may be an issue, right? And really the government wanting to ensure that if fraudulent job postings are out there, that, there's a mechanism for basically reporting them, and then a mechanism for employers to handle such reports. So certainly keep your eyes peeled. A great source for this sort of information and whether this is actually going to be implemented is through our blog. We really frequently write on upcoming changes. And so do, follow along over the next year or so to see if this passes and see if there's going to be additional, expectations when it comes to fraudulent job postings. Now, there are some other changes that are in the Working for Workers 7 Act, which again is a proposed piece of law, and it's going to create additional job leaves. Okay, now I'm not sure how impactful this is going to be to most employers, but effectively this will create a new unpaid leave entitlement specifically for employees who receive termination notice when 50 or more employees are terminated at the same time. So that's a pretty specific circumstance where, an employer is terminating 50 or more employees at the same time. But really what this is going to do is provide unpaid leave of up to 3 days during the notice period that would be provided to those employees, the notice period meaning the termination notice period. And it's going to basically give them 3 unpaid days to take off to conduct job seeking activities. So this is going to include things like going on interviews, job searches, and training. So again, sort of a specific circumstance there. Not sure if it's going to have a great deal of impact. Now, there is some good news here for employees, or rather employers. There's a new change proposed, and again, if passed, what it's going to do is actually permit an employer to lay off non-unionized employees for a longer period than is currently allowed. Now, as far as we can tell by the way that this law is written, a really important caveat here. Sounds like great news on paper, but it also sounds like this longer layoff period is actually going to require mutual agreement between the employer and employee, potentially director approval. So I'm not sure how often this is going to actually be utilized by employers. Again, it could really depend on, whether they're in sort of a working environment where they suspect they would get that mutual agreement. But some potentially good news there, a little more flexibility potentially for our employers. So those are some of the changes that are currently proposed in Working for Workers 7 Act, which again is before the legislature. We really encourage you to keep an eye out on these changes. Again, our blog is a good source of this information to stay up to date about whether these changes are actually passed, become law, and then create expectations in your workplace. Now, before sort of capping the presentation off today, we did just want to talk about some changes that we found particularly interesting that actually occurred in provinces other than Ontario. And for us, this is a bit of a forecasting mechanism, right? We can't help but look at these other changes and wonder, is Ontario going to sort of take a note from these other provinces and potentially decide to make similar changes here? So again, I really want to emphasize these are not laws that are currently enforced. They're not in Ontario, no immediate impact to our current employers. This is a little bit of speculation on our part to say, is this trend coming to a workplace in Ontario anytime soon? So a couple of interesting trends that we saw across the country. We actually saw two provinces, both Quebec and Nova Scotia, introduce changes targeted at protecting workers from psychological harassment. So again, as we discussed up front, here in Ontario, we saw this change for, a recognition that harassment was occurring virtually. Now, in Quebec and Nova Scotia, they took a bit of a different approach and they targeted, protecting workers from psychological harassment. So certainly, again, as a lawyer who frequently represents employees, when I saw this change kind of happen in Quebec and Nova Scotia, I was curious, okay, are we going to be taking a page out of their book at some point at the future and sort of codifying, again, a recognition that I'm sure most of you have, which is harassment, occurring psychologically in my workplace. We also saw a really interesting change, a couple of changes, frankly, at the federal level. Now, the federal level is, a special class of employers that are federally regulated. Usually, we're talking about companies like banks and airlines, things that cross provincial lines. Okay, so again, most of you listening today are most likely regulated provincially, but we saw a couple of interesting changes at the federal level. So at the federal level, we actually saw a new leave introduced, which was a pregnancy loss leave. And so there's actually now this special new sort of leave that employees can apply to take following the unfortunate loss of a pregnancy. We also saw at the federal level this new change, very interesting one, which takes basically a presumptive classification that an employee is an employee until proven otherwise by the employer. So this was really a fascinating change from my perspective, because this is sort of the old adage, if it walks like a duck or walks and talks like a duck, it's a duck, right? And so here, basically, federally regulated employers are basically being told, look, we're going to assume your worker is an employee unless you prove otherwise. And that's sort of not how things generally operate, right? So many of you listening in are well aware of things like independent contractors, things like that. And where that sours, there's a dispute. But basically, here at the federal level, they're telling employers, hey, the onus is going to be on you to prove to us that you are not that they are not an employee. Now, finally, just another kind of interesting change that we're wondering if we're going to see more changes to come. In Ontario, many people, speculated, as Calvin mentioned, that this change to the way we ask for medical notes, and specifically this recognition that you can ask for them for the 3 unpaid statutory leave days. Many people speculated, as Calvin said, was this a matter of putting a strain on our health system and trying to reduce that strain? And so we're sort of curious, and the sort of trends we're wondering if we're going to see, is this going to continue? Are there going to be more changes brought in to kind of further reduce the impact on, the health system when it comes to asking for medical notes? So moving on, just to sort of cap things off, what we're going to talk about finally are really the key takeaways of this presentation, so that it's clear sort of what you need to know. So again, in terms of some of the key changes that we've talked about today, we sort of categorize them into 4 big themes, right? We talked about the expanding protection for workers, new entitlements for job seekers, and new hires, an entirely new framework for gig workers, and evolving health and safety protections. And so, of course, the key takeaways are there's been a whole sort of new sort of laws that, fit into these themes that you as an employer need to be aware of. You need to know if they apply to you. And then, of course, finally, you need to sort of be prepared to implement these changes through these practical takeaways we talked about through this presentation. As a final thought, really for us, staying up to date with these laws and these new changes, they help you remain competitive. They help you remain capable of retaining your talent. Of course, you're legally compliant, and that's a key goal for you. But finally, from our perspective, it really keeps your workplace happy and healthy, which again, is an important goal that I'm sure each of you are striving towards. So that's our presentation content for today. We did want to save some time because we know that this is, a lot of information. And so we wanted to save some time to review some questions with you. So I'm just going to take a quick peek at the chat here, and I'll also ask Calvin to jump in as well, maybe just to kick us off. Calvin, are there any questions in there that you'd like to address?
Yeah, sure. There's one. Here's a very practical one. This has to do with AI, the new requirement that you have to disclose it on the job posting if you're using it. So here's what our participant is asking. Our company sometimes uses AI to help screen resumes. Under the new posting requirements, how do we properly disclose that without scaring off candidates? So here's the thing. You are not alone. More and more companies are using AI in some or any part of the job application process. In the States is where we have the data. More than 95%, I think it's more than 98% of Fortune 500 companies are using AI to kind of either sort through resumes or choose keywords or rank applicants. And so this is becoming increasingly common. You're not alone. This new requirement, as you mentioned, is to disclose that. And so you're not going to be the only one who's disclosing it. A lot of companies are going to be disclosing it. And so as we get more used to it, it will become, for some job applicants, it's not scary. But as we get more used to AI in the workplace, it will become less and less scary and more normal. I've seen this, putting a line at the bottom saying that we use AI as part of this process to help screen resumes, which is exactly what you said AI is used for. Keep in mind, though, that a lot of employees or future employees of yours are also using AI. So in that vein, maybe they wouldn't see it as scary. A lot of people now are using AI to help with their cover letters, with their resumes, even with their headshots. If you're interested, we have an entire webinar on AI on our YouTube channel. And we also have several posts about AI in the hiring process on our website, on our blog. So disclosure is important. You don't have to make a huge deal of it, but it's important just to put it somewhere that you're using AI. And this is something that more and more people are going to get used to.
Yeah, for sure, Colin. I think you're so right. Most people, I think, at this point are using AI in their daily life for one or another reason, or sometimes lots of reasons. And I really do think this extends to sort of the job hunting process. So I think that there is like a growing recognition amongst employees that that this is probably being used in the job hiring process. Of course, now there's going to be this expectation that you do address this in your job posting. It really reminds me of, when we went through introducing a couple of years ago the electronic monitoring policy in Ontario. And, that was another area where we had a great deal of concern from employers basically saying, now I have to tell my employees when I'm monitoring them. And I'm afraid they're all going to sort of, be very stressed out about this, revolt, the whole, the run the gambit of concerns. And I think, as much as you don't have to get into a great level of detail, I think what one sort of strategy you can take here is toying around with what level of detail you're comfortable actually providing that you also feel might put your candidates at ease. Obviously, it's of critical importance that you get these folks through the door and you want to fill this vacancy. And so I think, take some time in advance and sort of toy with some language around how can we be clear that we are using AI and how much do we feel comfortable disclosing about how we're using that AI that might help put these candidates at ease. So is there a one-liner you can include there that explains why you might be using it, or a little bit of detail of how you're using it, again depending on your comfort level, that you think might sort of potentially address some of the panic that the job seeker may come across. if they're actually taking a look at this.
That's right. In terms of, if I can add to that a little bit,
Of course.
that's right. I mean, it depends on what you're using it for that might make it scary or not scary, right? Some
Yeah.
companies in the States, and we've we've covered this on our blog and in the other webinar if you're interested. Some companies have gotten in big trouble. There have been a couple class action lawsuits. One involved a company using AI to analyze candidates' facial expressions during interviews. So a big question for you when you're implementing AI, and I think the participant, it looks like you're using it for a reason that you're not going to get sued over, screening, picking keywords, screening resumes. That's entirely reasonable. But think of the problem you're aiming to solve. If you have too many applicants, you want to sort through the ones to find the best ones. Yes, it makes sense to use AI to screen resumes. Is the problem that people who are hiring don't know how to read facial expressions? Maybe it's a problem with the person who's doing the hiring, and not the AI, because I do think that there are some instances of AI as some applications that candidates are not going to be okay with, that they're simply going to be uncomfortable with, and you can't blame them, because when we're trying to implement AI, we have to make sure that humans are making the final decisions. That's how we reassure people that robots aren't making a decision about whether you hire or not. We are. The robot is just helping us sort applications. So if you're relying on an AI to look at someone's facial expressions and analyze how suitable they would be for the role, that's maybe allowing it to do something that should be done by a human. Again, we have a lot more information on this on our website. But yeah, think about the problem you want to solve. And you know what? In these cases, transparency and disclosure actually may put people at ease.
Yeah, yeah, it's so fascinating. I mean, I did hear of a case last week where someone, was having what they sort of deemed as a strange interview and basically determined midway through the interview, okay, I'm not actually being interviewed by a real person. I'm being interviewed by AI. I can imagine how that would feel. Like it would be extremely shocking if you sort of discovered that mid-interview. I don't think we're necessarily going to be seeing a lot of employers going to those sorts of extremes. I think, like you say, Calvin, it's more or less, sorting applications as they sort of arrive into candidates that you want to interview or not interview. I think that's more likely sort of the things that our employers are going to be doing here in Canada. But, a growing concern is, really addressing how you want to use these technologies. And then, of course, with this new law, letting employees know, job seekers know that you are using them. So lots of fascinating things to consider. We also got another great question in the chat, just specific to probation and new hires, right? And so what I would say here is that we talked a little bit about sort of the training side of things today, whether people are considered employees during a training period. I think, my general advice on this would be really err on the side of caution. Assume that somebody's going to be considered a employee and get in touch with us to make sure that you understand whether that person's considered an employee, because there can be some pretty significant entitlements to employees really upon becoming an employee. So make sure you understand and get in touch if you need some advice. And Calvin, I think there might be some questions on the washroom side of things. If you could take a peek and maybe address those before we conclude.
Is that the one about how to keep proper records? That's the one you're
No,
talking
we
about?
actually have another question about, yeah, that's okay. There's a question there about, I think it's mainly about whether or not a lease would be counted as a washroom you have to take into consideration in terms of keeping clean. Which is a really interesting question that I'm not entirely sure we have the full answer to yet, just given how new this this law is, but do you have any thoughts you want to share about that? So again, if this washroom is on a leased property, but the employees are using it, what do you think? Do you think it's probably best to assume that this law would apply to that sort of scenario?
Yeah, that's a very good question from our participant. It's probably safe to assume that if your business, like you're right, a lot of businesses you don't own the building, right? You lease the building. Safe to assume that it still applies to you because it would be onerous to ask the owner of the building to do this. If you're employing people, it's your company, you just happen to be leasing a space. I think it's safe to assume that this applies to you. What do you think?
Yeah, I think so because basically the new law expects that employers are to maintain clean and sanitary washrooms for their employees, right? So there's an expectation that you're providing the washroom. And then I think, that sort of pairs with the expectation that it needs to be clean and sanitary. So if this is a washroom that your employees are using, I think, as a starting point, you need to talk to the person that you're leasing from and figure out how you're going to tackle this because as an employer, you need to, assume, I think, be on the side of caution and assume that this does actually apply to you. So with that, we've reached the end of our time together today. Thank you so much for everyone attending. We do have a webinar next month. It's actually on Wednesday, October 15th. It's going to be with two of our fellow colleagues here at SpringLaw, Jeff and Phil. It's going to be a great webinar. I would really encourage you all to tune in. It's on managing leaves. So they're going to be looking at medical leaves, LTD, and return to work strategies, something I'm sure most of you are coming across. And in the meantime, thank you so much for attending this month's webinar, and we hope to see you again soon. Thank you, and thank you, Calvin.
Bye for now.